A very good morning to those of you who have joined from the US, and a very good evening to those joining from India. I'm Manoj Balwani, National Executive Committee member of the Indo-American Chamber of Commerce, India. Alongside my work at the Chamber, I serve as the Executive Vice President at Citius Tech, and I have been privileged to contribute across diverse industries over the years. It's my absolute pleasure to welcome you all to this important webinar titled Navigating US Business Immigration in 2025, Key Updates and Practical Insights. It is truly wonderful to see two chambers, the Indo-American Chamber of Commerce in India and the Indo-American Chamber of Commerce Greater Houston, coming together, building on decades of connections and collaboration that have strengthened Indo-US business ties. Today's session is yet another step in that journey, addressing a subject of critical importance to our members. There's also part 2 of this timely webinar series on the Trump administration's newly imposed tariff, which is happening tomorrow for those of you who may be interested. This session will review the first 30 days of tariff implementation, analyze their immediate impact on businesses, and examine how companies are responding. So if you are interested in tomorrow's webinar as well, do reach out to us and we'll share the joining details with you. I would now like to introduce and invite our National President, Mr. A. Sekhar, to deliver his address. Over to you. And before I do that, I would want to just share a quick intro for Mr. Sekhar. Mr. Sekhar is a graduate electrical and electronics engineer and a postgraduate in business management with over 4 decades of an entrepreneurial experience. Through his company, Spike Power Protection Systems and Technologies, he played a pioneering role in bringing US-based ERICO to India and has since been active in renewable energy, aerospace collaborations, and social initiatives supporting education. He's been associated with the Indo-American Chamber in India for over 15 years, serving as a branch chairman of Tamil Nadu and also the Southern Regional President. So I now, with that, invite Mr. Sekhar, our National President, to deliver his address. Over to you, Mr. Sekhar.
Thanks, Manoj, for those kind introduction words. Good morning, my friends in the United States, and good evening to my friends and colleagues here in India. It's my privilege to address you all today. This is an important webinar on navigating US business immigration in 2025, the updates and practical insights. As Manoj said, this is hosted by both Indo-American Chamber of Commerce, India, and the Indo-American Chamber of Commerce, Greater Houston. We have been around for more than 5 decades as IACC and have served as a principal bilateral chamber committed to strengthening India-US partnership. Over these years, we have consistently worked to create platforms where businesses, professionals, and policymakers could come together and address the challenges and the opportunities of this dynamic relationship which we have. We are seeing the amount of dynamism, what is happening at this point of time. Immigration has always been a critical factor in the Indo-US business engagement. It enables seamless flow of talent, supports innovation, and fosters stronger business collaboration between our two countries. In 2025, with evolving US immigration policies, Indian companies and professionals must stay better prepared than ever. This change taking effect this month to the visa interview waiver program, as well as shifting trends in the employment-based visas for both H-1B and L-1, make today's discussion more timely and necessary. I am very delighted to have with us Ms. Emily Newman, an experienced and a highly experienced US immigration attorney, who will guide us through these latest updates and share practical strategies. I also want to thank Mr. Jagdeep Ahluwalia, and our partners in Indo-American Chamber of Commerce, Greater Houston, for their collaboration in bringing this initiative forward. IACC remains committed to supporting our members in navigating the complexities of the international business, and we believe that today's session will provide valuable insights for all participants. As Manoj said, we are following up with another one seminar tomorrow, which also takes into account about the tariffs. With these words, I once again welcome you all to this webinar, and I look forward to an engaging and a fruitful discussion. Thank you. Manoj, you are muted.
My apologies. Thank you, Mr. Sekhar, for your opening remarks. We are indeed very delighted to have Ms. Emily Newman as well as Mr. Jagdeep Ahluwalia with us today. Now, before I invite the
Robin, we lost Manoj.
He's back.
Did you say something, Mr. Sekhar?
No, we lost you in between.
Oops. Okay.
Yeah.
Let me just go again. Yeah. So we are indeed delighted to have Mr. Jagdeep Ahluwalia as well as Ms. Emily Newman with us today. And before I invite them in, I would like to quickly introduce the two of them. So I'll begin with Mr. Jagdeep Ahluwalia's introduction. Mr. Jagdeep Ahluwalia is the founding secretary and current executive director of the Indo-American Chamber of Commerce, Greater Houston. He also serves as vice chair of the Houston District Export Council. With over 35 years of experience spanning teaching, manufacturing, management, and consulting, he's been instrumental in forging alliances across Houston and India. He has been recognized with numerous honors, including the Outstanding Leadership Award by the Greater Dallas Indo-American Chamber, recognition by the India Culture Center, and leadership roles across Rotary International, the Mayor's International Trade Council, and the Houston District Export Council. Very delighted to have you with us, Mr. Jagdeep Ahluwalia. And I would now request you to share your initial remarks before we move on to Ms. Emily Newman. Over to you, Mr. Ahluwalia. Thank you.
Good evening to everybody in India and good morning to our friends in the USA. It's an honor and a privilege to continue to work with IACC India, with whom we signed an MOU more than 20 years ago when Hemant Bhai Sonawala introduced us to the leadership in Washington, D.C. And we continue to work closely with each other to provide value for our members. I'm also grateful to Emily, who took the time to be on today's webinar. Manoj just mentioned a Houston District Export Council webinar, which is tomorrow. It's on tariffs. It's free for IACC members, but if you want to attend, reach out to the IACC in India so they can give you details on how to register for that. It would be of value. Through the initiatives, we aim to provide our members with timely insights on issues that directly impact Indo-US business and professional exchange. Today's session focuses on the fast-evolving US immigration landscape and a topic of critical importance in 2025. This is the first in a new series of joint webinars between IACC and IACC India. Back to you, Manoj, for a very meaningful and impactful webinar. Thank you.
Thank you, Mr. Ahluwalia, for those thoughtful remarks and also for sharing news about tomorrow's webinar hosted by the Houston District Export Council, where you serve as the vice chair. It is now my privilege to introduce our keynote speaker, Ms. Emily Newman. But before I invite her on, I would like to give a short introduction about her. Ms. Emily Newman is managing partner at Reddy Newman Brown PC and is a highly respected US immigration attorney with 20 years of experience. She has helped transform her firm into Houston's largest immigration law practice focused exclusively on employment-based immigration. An alumna of Central Michigan University and the University of Houston Law Center, she's been quoted in Bloomberg Law, US News and World Report, Inside Higher Ed, and the Times of India. She's also a member of the American Immigration Lawyers Association, ILA for short, and the Society for Human Resource Management. Please join me in welcoming Ms. Emily Newman to deliver her keynote presentation on navigating US business immigration in 2025. Over to you, Ms. Newman.
All right. Thank you so much for having me. It's a pleasure to be here. I have a ton of information to cover because so much is going on in business immigration, so I want to get right down to it. But to start with, I do have a little bit of housekeeping. Just know that this information is general information for educational purposes. It's not meant to be legal advice for your specific situation. So please reach out to your own professional legal counsel for advice on your specific situation. So with that out of the way, what I want to get into today is really going over what's happening so far in 2025 in immigration policy and what we can expect going forward over the next 3.5 years of the Trump administration. And how does that really impact businesses, their employees, people who need to travel frequently on visas? What do you need to do differently to deal with these policy shifts? We'll go over all that's happening with changes to H-1B, L-1, and other work visas, as well as compliance, which is an important part of it during the Trump administration, and what best practices you should be considering for your business. So I want to give you a takeaway to start with, something easy to remember. What's going on in immigration right now are the 2 C's and the 2 T's. 2 C's are cost and compliance, and the 2 T's are time and travel. So if you take nothing else away from this, you'll have a lot of information. Number 1, cost. Everything dealing with US immigration is going to cost more. We have filing fee increases, visa application fee increases. You're going to want to file everything in premium processing, which is going to be an added cost. Legal fees are going to be more because there are going to be more requests for evidence, more notice of intent to deny, and you're just going to have to be providing a lot more documentation to the Immigration Service, which costs the company more time and money. Compliance should be a major focus of the company that is dealing with US business immigration, making sure your public access files for H-1Bs are up to date, making sure your I-9s are in compliance, and making sure for the perm recruitment process, if you're going through labor certification for the green card, that you are sticking with good faith recruitment and keeping all of your documentation for that. Time. Everything is going to take longer. So which is why you're going to need premium processing. There's going to be more requests for evidence, which take longer in order to get an approval. It's going to take longer to get visa interview appointments at the consulate. Visa stamping is going to take longer because we're going to see more administrative processing, or 221Gs, which I'll talk about. So just plan on everything taking longer. So start earlier and build in that extra time. Travel. If someone needs a visa stamp in their passport, they really should be avoiding travel if they're currently in the US. It is not safe for them to exit the US and apply for the visa stamp in many situations. A lot of people can get stuck abroad for weeks on end, maybe even longer, and it's very difficult for businesses to operate in that situation. So if you can avoid travel, that's going to be the best thing. And then just the anxiety, the fear, the stress that the employees are feeling as they're dealing with all of these changes and hearing all of these rumors, we definitely need to keep that in mind as we're talking through this with our employees. So one piece of breaking news that just popped up over the weekend is for third country national visa processing. So for people who are in the US on a work visa, for example, many of them will apply in Canada or Mexico to renew their visas, so they don't have to worry about doing it in India when they're there for a vacation or a business trip. That is no longer an option. So you're only allowed to apply for a visa in your country of citizenship or your country of residence going forward. So anyone needing a new visa has to go all the way to India to get that. And on top of that, that means that you can no longer shop around to different consulates for better wait times. So if we see, which we're expecting, major delays in getting visa interview appointments in all the consulates in India, we can't look to other consulates going forward in order to find an earlier appointment slot. We're just kind of stuck with it. And again, because of this change, we're going to expect more 221Gs, which is administrative processing that I'll talk about. So that's on top of the big news that just took effect last week, and that is the elimination of Dropbox or interview waivers. So for those people that were on a work visa or a business visa and needing to renew it, they used to be able to just drop off their documents at the consulate, not attend an in-person interview, pick up their passport or have it mailed to them, and now their process is done. It was a much easier, faster process in order to renew a visa when it was in the same visa category. That is all gone. Every single work visa now requires an in-person interview at the consulate, and now it's only in your home country. On top of that, we used to allow kids and senior citizens to avoid going in for an in-person interview. That is also gone. So now we're interviewing toddlers to make sure that they are not a security threat to the United States. All of this means that it's going to take longer to get appointments for your visa interviews because we have a lack of resources at the consulates. Our Department of Government Efficiency has cut a lot of positions at the State Department. And now that we're interviewing everybody and they can only interview in India, it's going to be really difficult to get a timely visa interview appointment. On top of that, because we are interviewing everyone, if they cannot immediately approve the visa, if there's any one little thing that's off or they need to look into in more detail, they are going to issue a 221G for administrative processing. What exactly does that mean? A 221G is basically a denial of the visa with the opportunity for it to be approved later once they do their additional processing. The problem with it is not a fast process. Sometimes it might take a few weeks. Many times it takes several months. And so if you're someone who was in the United States, left to go on a vacation over the holidays, went for their visa interview and got a 221G, you might be stuck there for the next 6 months without a way to get back. And you're losing out on that position in the United States. The company is losing out on that talent. So it's definitely best to avoid a 221G if you can. And so the number one way to do that is to avoid travel if you do need a visa stamp. So if you have a valid visa stamp in your passport, travel is really not that impacted right now. But if you do need a new visa in order to get back into the US, you really should consider avoiding travel, honestly, for the next 3.5 years. If you are going to travel, build in that extra time. Make sure that you allow enough time for a potential 221G, or at least put some contingencies in place so you can continue to operate in the event that you do get stuck abroad. Are you going to be able to work remotely, or is there someone else that can maybe travel in your place to avoid that issue? If you're in the United States, there are some situations where you might exit the US to apply for a visa in a different category. You may want to instead stay in the US and opt for a change of status by filing with the Immigration Service, again, to avoid these possible 221Gs and delays. When you are filling out the DS-160, which is the visa application form, very important to be consistent and be accurate in that information. So if you have an H-1B petition or an L-1 petition, make sure you're listing your job title, your salary, your work location exactly the same as it was in your petition. Make sure that you're listing your employment experience history with accurate dates and accurate company names. Make sure you're listing all of your employment history. Make sure that you are listing all of your social media handles, because they are looking into that now as well. And by making sure everything is consistent, you can reduce the need for them to have to look into things further and issue a 221G. And lastly, prepare your employees for the interview. A lot of it, up until now has been, it's, 2 minutes. You have a very limited number of time. They ask 2 questions. It's very easy. Going forward, they may want to spend a little bit more time preparing for the interview. I always recommend to my clients to come up with a 30-second kind of elevator pitch to explain why they're there at the consulate today, what visa they're applying for, and why they qualify for it, and then let the officer ask some questions from there. And then just go through maybe a mock interview so they understand what types of questions might be asked, so they know what to say and they're not taken by surprise. All of those things will help to potentially avoid the possibility of a 221G delaying your visa stamp. But if you're not able to avoid a 221G, what do you do if you get one? Number one, some of them do ask for additional documents, either from the employee or from the company. So make sure you're providing exactly what they're asking for. Number two is check the status of the case by logging into the IACC system. This is the same system you used to fill out the DS-160 form. It will let you know visa refused or visa approved or in process. And so you can just keep checking there to see if there's any updates. You may need to escalate it within the consulate if you're not hearing back. We typically recommend after 30 days, if you still haven't heard anything, reach out for the first time and then keep reaching out every 30 days. Each consulate has a different method for how to reach out to them. Some of them have email addresses. A lot of them now have moved to this Visa Wizard, which is like a Google form that you fill out that kind of moves you to the right flow and gets you to the right person in the end. And then lastly, if you are stuck for a long period of time, consider a lawsuit. We have been filing lawsuits under the Administrative Procedures Act, the APA, which basically says if a government agency is acting unreasonably in delaying making a decision, you can sue them. And so we've been doing that quite often, more and more for these 221Gs. Mandamus is kind of another term for that, but it allows the judge to say, hey, this is taking too long. You have to make a decision. Now, the decision could be an approval, it could be a denial, but at least you're getting a decision and can move on with life. Another big topic of concern are revocation of visas. So a few weeks ago, there was a big news article about the idea that the State Department is going to be continuously vetting the 55 million US visas that people hold worldwide. And so this certainly includes tourist visas, visitor visas, and that sort of thing, and may even include ESTA for those that are from other countries. But basically, any action that happens after the employee has received their visa, any kind of law enforcement interaction, could result in the Department of State revoking their visa. The Department of State has full authority to revoke anyone's visa at any time for any reason, and you cannot fight that in court. The only thing you can do is apply for a new visa. And we often see this most commonly with arrests for DUI, driving under the influence, or some domestic violence type situations. And the type of revocation is a little bit different. In the State Department, when they revoke a visa due to some sort of law enforcement interaction, they call it a prudential revocation, meaning that it doesn't actually take effect until the individual exits the US. And once they do exit the US, now their visa has been canceled. That means in order to return back into the US, they have to apply for a new visa at the consulate, go for an in-person interview, bring all of the documents with them, be prepared for administrative processing, be prepared that they could just deny the visa going forward. One other important aspect of visa revocations that people get confused is if you are subject to one of these visa revocations, it does not impact your status in the United States. So you actually can remain in the US even if your visa has been revoked. You can remain in the US if your visa stamp that's in your passport has expired. It's just the next time you travel, it's going to be an issue. And sometimes people get an email notification about the revocation. Sometimes they don't. And because they may not always get that email notification, it would be important to keep checking the status of the visa in that IACC system. Just log in every once in a while and make sure it still says visa issued or approved and it doesn't say revoked, because some people ended up traveling even knowing that their visa was revoked because they never got the email. Moving on to visa trends for particular visa categories. The first I want to go over is the H-1B, since that is a very common category for work visas. Number one, there was a new regulation that took effect in January of this year that requires companies to participate in a site visit. So up until this time, the government was doing site visits. It's through the FDNS, or Fraud Detection and National Security Directorate. They would send officers out to the company, to the employee's work location, ask some questions, ask for some documents, just to verify that everything that you mentioned in your petition is actually happening, that the job duties line up, that the person is being paid properly, that they're in the right work location, and that sort of thing. Up until now, you could say, you know what, this is voluntary. I don't want to participate in this, so you can just go on your way, and nothing would happen to the company if they did that. But as of January 2025, if a company refuses to participate in the site visit, that can be grounds to revoke the valid visa petition. So you do need to make sure that employees are aware that a site visit can happen, not only the H-1B worker themselves, but if you are working in office these days, your receptionist should be aware that someone from the Immigration Service could come in and start asking questions. They should be trained on who to contact, what do I do, make sure that they don't just give free rein to the officer. The officer should just wait there until the right person comes to be able to answer those questions. We are seeing more looking into prior compliance and non-compliance when you're filing an H-1B transfer or you're filing an H-1B extension. Up until now, they were just looking at, okay, did you maintain your status previously? Do you have your last 3 pay statements, is what it boils down to. Now they're actually looking at the last petition and saying, look, on this last petition, the salary mentioned was $90,000, but we see your paychecks from that company making it look like they were paid less than that. What's going on? Or we see in your prior petition, your work location was supposed to be New York City, but it looks like your pay statements are showing you're working in Houston, Texas. What's going on? So they are looking into that more in detail. We also are seeing them really second guess prior approvals, even though we have a new regulation that says that if you are filing with the same company, same employees, same job, same work location, everything is the same, and you're just filing a renewal, we should defer to that prior approval and approve the extension. We don't have to look into it as much. Even though that is in the regulation now, they're really limiting how much they're willing to defer to those prior approvals. So if someone who's had an H-1B before needs to still submit their education evaluation to confirm that they have the equivalent of a US degree, even though the government already decided in the last petition that this person has the equivalent of a US degree. We're also seeing beneficiaries, the employees being sponsored, are receiving biometrics notices. This typically is now happening where there's been some sort of law enforcement interaction. Maybe they were arrested, maybe they were just fingerprinted for some reason, and now they're being asked to go in for biometrics, get their fingerprints taken, and they will do a security check to verify that this person is the person we think they are. And then we see that, hey, this person has an arrest record. Now we're going to send a request for evidence asking you to provide all of the documents related to that arrest. What is the court disposition? Prove to us that this person is still eligible for an extension or a change of employer. We're also seeing the government using discretion a lot more to potentially deny things. So they have the discretion to say, because of your past actions, even though you meet all of the legal requirements for an extension or a change of status, we're going to use our discretion to deny it. And that can happen in some of these situations where there's been an arrest for a major crime and a conviction. Even though it's not something that makes them ineligible for the visa, they're still saying, well, we just don't like having this person in the country, so we're going to deny their extension. We're also seeing a scary issue with notice to appear, NTA. So this is how the government begins deportation or removal proceedings. We've never in 20 years that I've been practicing seen the Immigration Service start removal proceedings. It's always ICE that does removal proceedings, and it's usually dealing with people who are undocumented or people who've been convicted of crimes. Now, the Immigration Service has the ability to say, hey, we think this person is violating their status and overstayed. We are going to institute removal proceedings. And the sad thing is they've been doing it for people who are lawfully in the country, who've followed all the rules, doing everything right. So we've been fighting the government on those issues, just something to be aware of. Hopefully it doesn't grow, but it is happening. Also for next year, it's time to almost start thinking about the H-1B lottery season again. We typically start preparing for that in December and January. It's going to happen in March 2026. This is for visas that will take effect in October 2026. So we're getting ready to start having to think about that. Who are we going to be sponsoring? I'll talk about a proposed regulation that might change how that is going to be done. And then lastly, with H-1Bs, we have H-4 spouses who many of them hold an EAD because the H-1B applicant has an I-140 petition approved. These H-4 EADs are becoming problematic again for renewals, because if there is a gap between the time your previous EAD expires and the new one is issued, you may have to stop working. There is a 540-day automatic extension of the EAD, but it's not automatic. It doesn't work in a lot of situations. And so we're having to send people to Mexico in order to come back and get the documentation that they need in order to qualify for that. That is going to be continuing. So things to think about and be prepared for H-1B. Again, file early, use premium processing. Select the correct SOC code. So when you are preparing a petition, you look at the job duties and determine which occupation it falls under. Make sure you're picking the one that aligns best with the actual job duties, and that occupation actually normally requires at least a bachelor's degree in a specific field of study. Next, make sure you're picking the proper wage level for your prevailing wage. There's 4 different wage levels. You want to make sure that you're not picking a level 1 entry level wage for someone who's doing higher level work. Make sure nowadays that you include a very detailed job description in your petition. Include the education evaluation if they don't have a US degree. Make sure you're being consistent with what was stated in prior petitions. Be sure you're following the procedure for posting your notice of filing properly and have your public access file documents up to date. And there's a lot of talk in social media right now about H-1Bs, and they feel that, hey, why are these companies like Tesla and Microsoft laying off US workers and then turning around and hiring H-1B workers? They see that as a problem. However, there is no requirement for many H-1B employers to actually try to recruit a US worker first. That only applies to H-1B dependent employers that have more than 15% of their workforce on H-1B. But even if they are an H-1B dependent employer, it's possible that that particular H-1B petition might be exempt from this recruitment requirement if the person has a master's degree or they're being paid at least $60,000 per year, which is very common. So not a lot of employers are actually required to recruit US workers before they sponsor an H-1B, but in the media, it sounds like people are thinking that that has to happen. Moving on to L visas. These are requiring that you spent 1 year abroad within the previous 3 years in a particular type of position in order to qualify. Be aware that any time that the person has been in the US during those 3 years, if they came on a business visa, for example, that kind of subtracts from that 1 year qualification requirement. And based on the current trends, we're really seeing 1 year may not be enough. So although the regulation says this person had to work for 1 year for our company abroad before we can send them into the US, they're really questioning, well, how could that person have gained the type of specialized knowledge needed for the position in just 1 year? So you may need to start looking at your employees that you're planning to bring to the US and choose people that have been with the company for a longer tenure in order to improve the chances of getting the visa. For an L1A, the position abroad and the position in the US should have been managerial or executive. They can be a people manager or a functional manager. They need to have decision-making authority, clear organizational chart showing that head count and that they have budget authority. If you're going for the L1B category, what makes this person special? What do they know about your company and your products and your processes that is more than what other employees might know? You may need to provide that comparative evidence to show that this particular employee has gained X experience and does more than the other employees of the company. And then if you're using the blanket L for larger companies, the standard when you're going straight to the consulate is clearly approvable, which is actually a higher standard. And so you may see a denial from the consulate saying this is not clearly approvable. And that's particularly been happening for L1Bs right now, where again, they're saying that, well, if you've only been with the company for 1 or 2 years, it's not clearly approvable. We don't think you truly have that specialized knowledge yet. If the individual is in the US on a blanket L, although you have the option of sending them back to their home country in order to renew and extend their L, we recommend processing it in the US by filing with the Immigration Service. Because again, we don't want them to get stuck outside the US with the 221G or even end up with a denial, even though they've been approved previously. So for best practices on L1s, we want to make sure, again, we file early because it's going to take longer. There's going to be requests for evidence. Use that premium processing. Consider if you're filing for an L1B, making sure that the employee has more than 1 year of experience. Functional managers are more highly scrutinized, so you may want to avoid filing for those right now. Make sure your job description is very detailed and specific for your company. And especially for those applying under the blanket, make sure they're well prepared for the interview. They have that elevator pitch talking about how great they are and what they know that's special compared to other people. If you are outside the US and have the option to use the blanket, definitely do that. Avoid filing with USCIS if you can. But on the opposite side, if you're in the US and need a renewal, even if you have a blanket, file with USCIS, avoid going to the consulate so you don't get stuck abroad. All right, onto the green card side. Right now, we have a issue with priority dates. There's a backlog for India that is caused by the 7% cap. We only have 140,000 green cards available. Those are divided up into EB1, EB2, EB3 categories. And within that, only 7% can go to India because India has a large population. There's a very high level of demand. We see major wait times. So even the EB1, the Einstein green card, or the green card that is for managers or executives, it's a 3-year wait in order to receive a green card today. EB2 and EB3 is really a 12-year wait, but it's actually way worse than that. If someone were to be sponsored today for the EB2 or EB3 category, and they happen to be born in India, it literally could take 80 years. They are likely to be retired before they ever receive the green card. Some recent announcements in the green card is the EB1 and EB2 green cards have been used up already for this fiscal year. Very common to happen in the month of September because September is actually the last month of the fiscal year. But what it does mean is they cannot approve any EB1 or EB2 green cards from now until September 30th. Once September 30th rolls around and we move into next year on October 1st, we get next year's full 140,000 allotment of green cards. They should be able to start approving again. And EB5 is the only category where a green card is actually immediately available for someone from India. So if you've got someone who just doesn't want to deal with these long waits in EB2 or EB3, they really might want to consider that EB5 category, but the window is closing fast. In the next few months, it's very likely that there's going to be a cutoff date and a backlog in EB5 for India as well. Some strategies to think about with the green card process if you are sponsoring someone for the PERM labor certification. This is the first step in most EB2 and EB3 green card processes. PERM is taking forever. It's taking months to get a prevailing wage, and then it's taking over a year to process the labor certification. These are supposed to be processed in 60 days when they created this perm process, but it is taking 14 months right now. It's become a big problem for those that need that perm in order to get their H-1B extended beyond the 6-year limit. So you really need to start that perm process way earlier than you normally would. Make sure that all of your I's are dotted, your T's are crossed, the file is audit ready, you've gone through and done the good faith recruitment, really looking to see if there's a minimally qualified US worker for that position. You need to be careful about how you're setting your minimum requirements for the position, because that is what you're stuck with in order to determine whether a US worker is qualified or not for that position. And because of the economy right now, because of the job market, you may not make it through the perm process. It's very possible that you might go through all of the recruitment and find that a US worker is actually available, and then you can't proceed. So what do you do in that situation? You may want to look at the national interest waiver option, which avoids the perm process. And it's something that the employee can sponsor themselves for. There's also the EB-1A option, which is self-sponsoring. That is the Einstein Green Card Extraordinary Ability. So it's a high bar, but something to consider because, again, it avoids the labor certification process. If you are a multinational company, you could consider the EB-1C category, possibly sending the person back outside the US to work in a managerial capacity for 1 year, and then they can come back into the US and qualify for the EB-1C category, which is slightly less backlogged. With EB-2 and EB-3 being very close to the same cutoff date in the visa bulletin, people typically who have an EB-2 approval are also able to get an EB-3 approval, and they can convert back and forth between the two categories depending on which one is further ahead. It's called a transfer of underlying basis. So if someone has an EB-2 approval and EB-3 is further ahead, consider whether that may be an option. Cross-chargeability, if the person's spouse is from a different country, not India, you could use the spouse's country of birth in order to complete the green card process and not be stuck with those India backlogs. And lastly, because of these backlogs, we are going to be seeing more and more kids aging out. These kids are coming to the US on H-4 and L-2 with their parents when they're very young. And if the parent does not complete the green card process by the time the child turns 21, the child will age out. They're having to then change status to F1 so that they can continue their studies in the US. And then they convert eventually to an H-1B and end up in the exact same line that their parent is in. This is going to be a continuing and worsening problem over the coming years. What can you do when things go wrong? We're expecting to see more denials by the Immigration Service, by the Department of Labor. And so what are your options there? You basically have 3 options in most cases. You can file an I-290B, which is an appeal or a motion to reopen or motion to reconsider. Depending on the reason for the denial, sometimes it's easiest and fastest to just refile the application if you can clean up any of the defects, update the evidence, but you've got to make sure that the person is maintaining their status. But more and more, you may need to look at litigating. When the decision is arbitrary or capricious or an abuse of discretion, you can bring a lawsuit in federal court in order to fight that denial. Tends to be faster. Because we usually hear back within 60 days versus filing an appeal, which might take 6 to 8 months. And we see a lot of success with litigating. So that's something that you might need to bring in your tool belt as a company going forward. We used to be able to rely on the USCIS ombudsman or be able to reach out to a congressman for assistance or use a liaison. Those are really not working anymore. So litigation may be the way to go in the future. One of the things that people need to be prepared for is when something gets denied unexpectedly. We're going to see that happening more and more, and it causes a sudden status loss. What do you do in that situation? Well, the first thing is to avoid that sudden status loss. There are many times when these things can be avoided, and the best way to do that is to file early. So if you're filing a renewal for an employee, you can file it 6 months in advance. And if that renewal application unexpectedly gets denied, but the denial happens before their current status expires, Now they have options. They can turn around and refile. You could potentially file an appeal. They could file a change of status to another visa category while you work out what happened with the denial. It's very important to file early to get a decision before the current status expires. This may require you to use premium processing. So again, that added cost. We recommend, again, not traveling if someone needs a visa stamp. And if they do travel, every single time they come into the country, it is so important that they go onto the CBP website and check the I-94, because many times the I-94 end date is being cut short based on a passport expiration, or sometimes based on an old visa being expired or getting ready to expire before their status normally would expire. If that happens and the employee doesn't catch it before this shortened I-94 expires, it puts them immediately out of status and they start accruing unlawful presence. It becomes much more difficult to fix it if the I-94 has already expired. But what do you do if an employee suddenly has a status loss issue? Number one, again, we look at, has the prior status expired? Because if it hasn't, if that I-94 is not yet expired, we may be able to simply refile and the employee doesn't have to uproot their life and move back outside of the US. If it was a transfer situation, maybe they can go back to that previous employer. If their I-94 is not yet expired, they may be able to file a change of status to B2, a business or visitor visa, just kind of as a backup to buy an extra 180 days of time for them to remain legally in the country to figure out how to overcome the sudden status loss. There's a provision called nunc pro tunc, where you may be able to refile something late if you can prove that the late filing is due to extraordinary circumstances beyond your control. This may be harder to do in the Trump administration. So it might be, again, always better to get a decision before the status has expired. Sometimes it's necessary to travel in order to regain status, but we need to make sure we understand if that travel is going to trigger any problems, if they're going to need a new visa stamp in order to be able to come back. If they do travel, most people, if they're going in their home country, should be able to work from abroad remotely. The law that applies, the immigration law that applies, is where the person is sitting. So if someone is sitting in their home country of India and doing work for a US employer, US immigration law does not apply. They're in their home country. So you may be able to work remotely in that situation in order to wait for a visa interview or wait for a 221G. What do we do, again, in these status loss issues? I've created this framework of triage of things to consider, kind of a little checklist of what to go through. The T stands for time check. Number one, the first thing we look at is, what is the deadline? Is this person out of status? Is this person going to go out of status to where we need to file quickly? Or are we going to file an appeal where our deadline is 30 days? Make sure we know what the time crunch is. Number two, what are the risks? Is there a risk if they travel? Is there a risk that they won't get the visa to come back? Is there a risk to the company if they remain in the US? Are they working without authorization because of what's happened with their status? We want to identify the facts of who decided what, so that we know which agency we're dealing with. This could be the US Immigration Service, this could be the Department of State, this could be the Department of Labor. All of these agencies are involved in the immigration process, so we need to understand where the decision is coming from so that we know what to do. Then we can come up with our action options. Do we appeal? Do we refile? Do we have the person travel? Are they going to need a waiver? Then we want to make sure the company is clean. So that's governance. Do we need to do anything with our I-9 based on this situation? Are our LCAs up to date? Is our public access file up to date? Do we need to file an amendment because of whatever happened in this situation? And lastly, because of that stress and anxiety and fear, we want to make sure that we're being empathetic with the employee and supporting them when we're dealing with their issues. All right. Changes coming in the pipeline. I know I've covered a lot and we've got more changes on the way. I mentioned earlier about the H-1B lottery coming up next year. There is a proposal. We don't have the actual text of it yet, but it's expected to come any day now. That will change the lottery from being a random draw to actually being distributed based on wages. So the highest paid worker is going to get the visa before the lowest paid worker. There are some statutory things that are problematic with this idea, because the statute says visas should be granted in the order received, first in, first out. And so by doing it by wages, it's not aligned with the statute. So I expect there's going to be a lawsuit on this, but their plans are to make this take effect for the March 2026 lottery. Another new regulation we're expecting is more H-1B compliance. It has not been published yet. It's just going to be a proposal when it is. But if you're dealing with third-party placements where you're placing an employee at a client site, we're expecting to see more oversight, more documentation required in order to get those approved. We are expecting, well, we actually just have the proposed regulation announced for F1 students. So if you are having any students who are on OPT or STEM OPT or using CPT, what they're wanting to do is limit the amount of time an F1 student can remain in F1 status, so that they're initially let in for only a maximum of 4 years if they're doing a bachelor's degree program. Or if it's a master's level program, it'll be however long it's going to take them to finish that master's degree. And in order to extend beyond that date, they'll now have to file an additional application. So when it's time for them to file for their OPT or their STEM OPT, they're going to have to file an I-539 application along with it to extend their stay. It's just a proposed regulation. It's in the comment period, so it may be a couple of months before we actually see a final regulation, but I expect that is going to be coming through. We're also seeing that at the end of October, they plan on eliminating paper filing fee checks. I think there's a lot of problems with this because the system that they're using for using ACH bank transfers or allowing you to pay by credit card is a very paper-based system. So someone's going to have to be hand entering in the information of your bank account, which is a little scary to me. So it might be delayed. I'm hoping it gets delayed because I'm not looking forward to that, but just be prepared. If you do submit paper checks with your filings, you may have to start doing bank transfers instead. And then we're expecting a proposed regulation on I-140 petitions, which we've not really seen any regulations addressing that anytime in the last 20 years. But they're really going to be looking at, is the person being sponsored for a real job offer? They're potentially going to be adding site visits to I-140 petitions. They're going to be looking at how we determine whether a company qualifies as a successor in interest in the event of a merger or an acquisition. How do we establish the ability to pay? And then they're really going to be looking at that EB1 and the national interest EB2 standards and modernizing that as well. All right, so to wrap up, I just wanted to kind of go through some best practices to be aware of as you go forward. Number one, again, acknowledge that employees are dealing with a lot of stress and anxiety. You may want to consider providing them with regular updates, being compassionate about them, providing them with access to legal guidance, making them aware of some good resources for them to follow so that they're getting the updates without getting all the hype and the kind of the fake news that happens with a lot of immigration. Make sure as a company you're tracking expiration dates so that you can make sure that you're doing your I-9 compliance on time and are filing those extensions early. Start the green card process early because the perm process is taking so long. Make sure you're maintaining worksite compliance. So if your employee is moving from one location to another and they're on an H-1B, you have to file an amendment first. You have to post a notice of filing at the new work location. Be ready for site visits, know what to do, make sure your staff is prepared for that as well. Discrimination is a hot topic right now when it comes to immigration because up until now, when we're talking about discrimination and hiring, the government is really focused on making sure that minorities were not being discriminated against. Now it's the opposite. They want to make sure U.S. workers are not being discriminated against. So make sure when you're going through your hiring process, as well as the perm recruitment process, that you are following all of those regulations to ensure that you are not favoring a foreign worker over a U.S. worker. If you are terminating an employee, make sure who's on a work visa, make sure you're going through that proper process. You have to provide notice to the employee. If they're on H-1B, you have to withdraw the petition and offer to return transportation to their home country, because if you don't do all three of those things, you could be liable for back wages. Make sure your public access file and audit files are up to date. And again, file early when it comes to the green card process. Consider options that don't require the labor certification in order to keep that green card process going in case you're having difficulty with the recruitment process. And make sure you're staying up to date on all of these policy changes. It is feeling like a whirlwind. During the previous Trump administration, we kind of joked that every Friday there was something new that was happening, and we're getting into that situation again. Make sure employees feel supported about that, provide them with realistic timelines and kind of alternatives and contingencies. And if you are dealing with any student who's on a STEM OPT extension, make sure that you are following that training plan that you filled out in your I-983. All right, I think I've made it through everything. I know that was a whirlwind of information. Hopefully I left enough time for some questions.
Wow, that was wonderful, Ms. Newman. Thank you for your insightful presentation. In fact, I would go on to say that it was ultra detailed and super comprehensive. And although you have covered most of the information that may be relevant in today's context, there are a few questions. So I'll quickly see if I can get those answered by you. Firstly, people want to know whether you would be able to share these this deck of slides.
Yeah, I'd be happy to.
Okay,
I can
wonderful.
share it with Robin and you all can distribute it as needed.
Okay, I'm going to skip the questions that you may have already touched upon. There's a question on the anticipated H-1B lottery process changes, and I think you already spoke about it. There's an interesting question here that if you have applied for a tourist visa and because of the waiting time being so long, if the situation for that particular beneficiary or applicant may have changed with respect to the purpose of the visit or the location of the visit, changed from what he mentioned in the application, how do we handle this?
Yeah, so it is very important for at least 48 hours before your interview, when it finally comes around, to update your DS-160. So you are able to log back into that SEAC system and retrieve your previous DS-160. Depending on exactly how you filled it out, you may have to start a new one where you copy it into the new one and then update your information so that and print out the new barcode with that new DS-160 when you go for your interview. But yeah, definitely update that before the interview.
Okay. One more question. Apart from the continuous vetting of visas that may revoke a B1, B2 visa that was granted earlier, are there any other issues that may impact the B1, B2 visa category?
I think it's going to be a bit of a moving target. So if you're familiar with the big ICE raid that just happened at the Hyundai plant in Georgia, 400 people from South Korea were picked up by ICE. They were on B1 visas. They were using the B1 in lieu of H-1B category, which allows a company to bring in someone who's an H-1B level employee for short-term temporary needs. And all of these people received the visa from the consulate for that purpose, were granted entry by CBP for that purpose. And then ICE turned around and said, nope, we think you're here working without authorization. We're going to pick you all up. So there's definitely more scrutiny of activities that are being done on a B1 visa specifically for business. Make sure you're doing business and not work. And it is a very fine line. That would be kind of the first thing I would suggest to be prepared for.
Okay, I'll take one more last question as we are almost running out of time. And my request to all those of you who have put in questions, but if your question is not picked up, please rest assured that we will reach out to you and get Emily to answer your questions for you and email the response to you as soon as possible. But I'll take one more question and let me see which would be the most relevant and interesting here. Yes, there's a question on short-term visits for bringing along students on exchange programs or educational camps. Is that process still very strict? Can you please guide on that?
I'm not sure if it's related to bringing them on a visitor visa or an F1 visa or a J1 visa. So I may need a little bit more information.
All right. So then in that case, we would request this participant to share a more detailed question, and then we could share that with you. So since that didn't get answered, I'll probably pick one more, the last one. Yes, one of the participants wants to know if they can reach out to you offline for advice on how to overcome 221Gs.
Yeah, absolutely. My email is there, emily@rnlawgroup.com. I'd be happy to support that.
Right. Thank you, Ms. Newman. And I think it's time for us to wrap up this session. And thank you for your detailed insights and practical guidance. Thanks also to the audience for all your thoughtful questions. This has been a truly valuable session on a topic that impacts so many businesses and professionals. But before we conclude, I would like to take a moment to extend our gratitude to everyone who's made today's webinar possible. On behalf of the Indo-American Chamber of Commerce, I would like to extend our sincere gratitude to our partners, Indo-American Chamber of Greater Houston, and especially to Mr. Jagdeep Ahluwalia for joining hands with us in organizing this timely and insightful session. A special thanks, of course, to you, our keynote speaker, Ms. Emily Newman, for sharing your deep expertise and guidance on navigating US business immigration in 2025. Your presentation has given our audience and members much needed clarity and direction on a complex subject. I would also like to thank our national president to take time out, Mr. Sekhar, to be able to take time out and join us today, and of course, all the other dignitaries who may have joined us. Finally, my appreciation to all of you, our members and participants, for taking the time to join this evening. Last but not the least, my appreciation to the organizing teams of the Indo-American Chamber here in India, as well as Greater Houston, who have worked diligently behind the scenes to make this webinar possible. We look forward to continuing this series of collaborations between our two chambers and to welcoming you all to our future programs. Thank you all very much and have a very good day to all of you. Thank you.
Thank you.